Hi, I'm Stuart Benjamin. I am the William Van Alstyne Professor of Law at Duke Law School, and I'm here to talk about the First Amendment, the FCC, and there's two Supreme Court cases here that are central. The first is a case known as Red Lion, in which the Supreme Court upheld FCC regulations that required broadcasters to give airtime to people that they had criticized. And the Supreme Court held that the FCC had the authority to make sure that we, the people, were getting access to a balanced presentation of views, and therefore the FCC could have this control over licensees to require them to provide space to voices they might otherwise not want to provide space to. The second case is known as Pacifica, and that was one in which the Supreme Court upheld restrictions on broadcast licensees' ability to air indecency. Notoriously, that was George Carlin's sketch involving the 7 dirty words you couldn't say on the radio. In later cases, the government saw fit to try to regulate other modes of communication. And in every one of those cases, the government said, oh, under Red Lion and or Pacifica, we can engage in this regulation. This is the same kind of regulation. And in every one of those cases, the Supreme Court rejected the underlying regulation. So as to Red Lion, there was a case 5 years later involving the Miami Herald. Very much same kind of law. You had a right of reply, and the Supreme Court unanimously rejected it as interfering with the free speech rights of newspapers. And as to Pacifica, the government has seen fit to regulate every other means of communication, internet, cable television, even telephones. And in every one of those cases, the Supreme Court said that Pacifica applied only to broadcasters. So we're in this unusual situation in which we have a regime that is broadcast specific, and that the Supreme Court has specifically rejected for all other means of communication. So broadcasting, and only broadcasting, is subject to this much lower level of First Amendment protection, or to put it differently, the government has a much greater ability to regulate broadcast television and radio than it does any other means of communication. And I mention all of this because that is the source of power that the FCC has, that it can deny, renewal, or transfer. And that authority that it has, that broad public interest authority, rests on the Red Line and Pacifica cases.